Thank you, Chair. Attorney, I recognise the investment in the public trustee for the future operations and improvements there, but I'm concerned about the last 26 years of operations, where clearly Damien Bugg has indicated that they've failed to understand their functions. Do you agree that over that 26 years of operation that individuals have been significantly harmed, and is it appropriate that applicants are required to make an application to the very organisation that they believe has mismanaged their funds and has failed to act in their best interest?
Thank you for the question, Ms Johnston. I know that this is an important area of interest for all of us, not, as I said, not least of all myself. That's why I called the independent review. That's why we have the recommendations as a result of the Bugg review, and that's why the government has worked towards implementation of all of those recommendations. Some are faster than the others. In relation to the calls for compensation, the Bugg review didn't recommend that there be a compensation scheme as such. I have made the observation that for any person, and this is across the board, can apply. Well, I'm reluctant to even say apply. There can be a situation where an ex gratia payment is made in circumstances where there are no other avenues. The language you've used of applying to the public trustee, the ex gratia system is basically governed by the Treasurer's instructions. There's a Treasurer's instruction on this. And so there's a process there if an organisation actually recommends to the government to look at that. So it's not a matter of applying as such, but certainly if it's a case where there's been actual loss, they may look to the government to make an ex gratia payment. I might add that if there has been actual loss or property loss, for example, that I think in the past there's been occasions where the public trustee would make that payment themselves without the government even needing to make an ex gratia payment. So there's not that structured process to go through as you're intimating. And what the government is doing is following the recommendations of an independent review, and that independent review found, and I want to use the language that was used there. Sorry, I'm just trying to turn it up so that we have the correct language. Basically, that there weren't fundamental failings to require an actual compensation scheme.
Okay, so putting aside for a minute the appropriateness or otherwise of the ex gratia payment system, if the Guardianship and Administration Board has deemed that a person lacks capacity requiring the appointment of an administrator, what reassurances can you provide that the public trustee will provide them or their family members or other interested parties with a copy of their file so they can properly assess whether an application should be made? What evidence should they provide in support of the application? And will funding be made available to legal assistance providers to provide legal assistance to applicants intending to make applications?
And I'm not meaning to be rude here, but you're failing to understand the Treasurer's instruction process. It's not an application that is made. I think you're trying to make it seem like it's this complex process. In the past where and ex gratia payments are actually quite rare, because often in circumstances where there's wrongdoing, an organisation can recognise that wrongdoing and often make recompense themselves. So as for the ex gratia system, not related to this in any way, I've received correspondence where I've thought that there's wrongdoing and there's absolutely no avenue, and applied by writing in a letter to the Treasurer for an ex gratia payment. It's not a process where there's this application process. You're sort of making it seem like there's this big long
Requires
process that
people who
people
are
need to
extremely
go
vulnerable.
through. Yeah. Oh no, look, I'm not doubting their vulnerability.
at least
so
some
please
kind of
don't put words.
representation.
Please don't make it seem like I'm doubting people's vulnerability. But in relation to providing personal information, there is the PIP Act, of course, that needs to comply, and there's certainly never any deliberate or willful obstruction of that process other than to follow the law. So I would encourage those who need legal advice. As I said, we've provided significant additional funding to the legal assistance sector to ensure that they can respond not only to increased demand for legal services for our most vulnerable as a result of COVID, but generally because there are people in the community who need that assistance. So this is sort of a multi-pronged approach here in relation to, we've provided funding to the legal assistance sector, so that's available for people who need it in the community that don't have access to a private lawyer or can't afford it. And then, as I've said, if there's a specific wrongdoing or actual loss incurred by vulnerable people as a result of the public trustee over many years, and there hasn't been any if I use the example of where the public trustee may have lost property, then I would obviously indicate my strong support for the public trustee to ensure that they either find that property, or if it's gone, that the public trustee look at recompensing the person themselves. And I'm sure they would in that situation. We have a new CEO at Public Trustee, Todd Kennedy, who is very actively involved in pursuing the reforms for the public trustee, and has a very strong positive desire to work with Advocacy Tasmania and other organisations who called for this to highlight the issues with the public trustee. Public trustee has admitted and said that it will support all of the recommendations as a result of the independent review, and so I would be encouraging the public trustee to work with vulnerable Tasmanians, and indeed through Advocacy Tasmania as well, to continue to rectify the circumstances of some individual cases.
Ms. Haddad.